In the It Ends With Us / Blake Lively and Justin Baldoni litigation, so much has been happening lately that it's been tough to keep up with everything. Part of that is because recently all or almost all of the so-called Lively parties have filed motions to dismiss Justin Baldoni's first amended complaint. And Blake Lively's husband, Ryan Reynolds, is one of them. And reading through the filings going back and forth on this specific issue, Reynolds' motion to dismiss, I can't help but come away with this one thought. Reynolds may have made a mistake in filing this motion to dismiss, and for a number of reasons.
Big mistake. Big. Huge.
Let's get into it. Okay, so in my last video, I talked a lot about Blake Lively's motion to dismiss and how there are some things that would concern me a bit if I were Justin Baldoni. A lot of people didn't like what I had to say about Lively's legal privilege arguments, telling me that I was wrong, etc., etc. But you know what? That's totally okay. I can give my opinion on things and you guys can give me your opinion back. We don't always have to agree on everything. And there's always a possibility that I could get something wrong here. And if I do, I always try to do my best to correct the record. I will say that the Wayfarer parties also recently filed their opposition to Lively's motion to dismiss. And once I have had a chance to sit down and go through that, I may have some updated thoughts on everyone's arguments. But either way, I just want to point out that one thing that's, I guess, good about all of this is that, you can expect me to give my true opinion on these matters, whether it's popular or not. However, as I've said before, I always reserve the right to change my opinion on any of these issues based on new information and persuasive arguments. And when that happens, I really try to be as clear as possible for transparency's sake. And otherwise, I just try to call it like I see it. Now, in this particular case, I do tend to side with Baldoni's side more often than Lively's side in this litigation. And that's really just because my analysis of the facts and the arguments, it tends to point me in that direction. I have no bias towards Baldoni or against Lively in this case. And if anything, I actually really liked Ryan Reynolds' humor before all of this. Just as an example, Deadpool v. Wolverine was the last movie that Mr. Bites and I saw in theaters before Baby Bites was born. Much to his chagrin, I was the one that chose the movie. He's been tired of superhero movies for years now. I'm a little fatigued by it myself, but it definitely took me a lot longer to get there than it did for him. And I made an exception to Deadpool because of what Ryan Reynolds brought to the character. And also, there really was so much for a millennial woman to love. Baby, bye, bye, bye. Don't wanna be a fool for you. I also always really liked the relationship that Reynolds and Lively had. I mean, at least the relationship that they showed on social media anyway. I found their banter to be really entertaining and endearing and likely a sign of a healthy couple. But now I don't really know about any of that after all of this litigation has brought up a lot of this stuff, and I'm way less charmed by all of it. At this point, I don't know how much of that was real or maybe some sort of synthetic image cultivation for the purposes of, marketing. Anyway, this has been a little bit of a side rant. Let's get back on track. Putting all of that aside, let's talk about Ryan Reynolds' motion to dismiss. But actually, before I do that, I have to thank this video sponsor. This video is sponsored by Raycon. This Mother's Day, treat your mom to a new pair of everyday earbuds by Raycon. Moms deal with a lot, and most likely your mom probably could use a moment to relax, recharge, and enjoy her favorite music, podcasts, and phone calls with great sound and clarity. I say this as a new mom with a baby. Being a mom is one of the best things that has ever happened to me. But it's also nice to have those rare moments to myself when the opportunity presents itself. For example, I love using these Raycon everyday earbuds when Baby Bites is napping and I need to take care of things around our home or get some work done for the channel. They come in a spectrum of vibrant colors, and they also have a really long battery life, 32 hours on a single charge. And when you do need to charge them, it takes just 10 minutes of charging to get 90 minutes of battery life. You can charge them wirelessly with the earbuds' awesome protective case cover. And while I'm listening, if I need to, for example, switch very quickly between my phone and my laptop or vice versa, I can do it very easily with the multi-point connectivity to pair with two devices at the same time. So if you want to support the channel and at the same time buy your mom an affordable yet thoughtful gift for Mother's Day, go to buyraycon.com/Legalbytes to get 20% off site-wide. And thanks again to Raycon for sponsoring this video. All right, on to Reynolds' motion to dismiss. For starters, none of those legal privilege arguments I went over from Lively's motion to dismiss are at play here. That's because there's no allegation that Reynolds filed some sort of a sexual harassment complaint in a workplace, or that the statements that he allegedly made arise from a lawsuit that he filed or some sort of litigation activity, or that he should be entitled to the fair report privilege for any reason. He does still make a lot of arguments in his motion to dismiss, and going over all of them in one video is a bit overwhelming, so I wanted to focus on what I saw as maybe his strongest arguments. Namely, when arguing that the defamation claims against him should be dismissed, he talks about the specificity of the pleadings, about the defamatory statements that he allegedly made, and he talks about impermissible group pleading. Now, I will say that in a case like this, where there's just so much detail that's been thrown around everywhere and from all sides, it's easy to get lost in the weeds. And here, Baldoni and the Wayfarer parties have alleged this whole long timeline of events that they say gives rise to various claims. And at the same time, we do have one group of people and entities suing another group of people and entities. And in cases like that, it can actually get confusing to tease out which conduct the plaintiff or plaintiffs says gives rise to which claim. And so all of this gave Reynolds and the others an opportunity to make the argument that Baldoni's and the Wayfarer party's first amended complaint isn't specific enough to be sufficiently pled, and at the same time that it impermissibly groups all of these various defendants in what's called a group pleading. So let's start with the specificity issue. When it comes to any complaint or amended complaint, there are certain pleading standards that need to be met in order for the litigation to move forward. One of these is specificity of the factual allegations. And by that, I mean the plaintiff needs to plead enough facts to put the defendant on sufficient notice of what it is that the plaintiff says that the defendant did that was unlawful, and that is so that the defendant can put on an adequate defense. And so here, Reynolds argues that as to the defamation claim, Baldoni doesn't plead enough to put Reynolds on notice about what statement Reynolds made that Baldoni says was defamatory. Specifically, he says that Baldoni fails to give the exact words spoken, the time, or the audience of the statement. And so he says, essentially, how can I defend against a defamation claim if I don't even know what Baldoni claims I said? In their response in opposition to Reynolds' motion to dismiss, Baldoni and the Wayfarer parties argue, look, we gave plenty of specificity about these various statements and certainly enough to satisfy the pleading standard. Specifically, they identify two statements from the First Amendment complaint that they say Reynolds made that they also say were defamatory about Baldoni in particular. The first is the July 15th, 2024 statement by Reynolds to Baldoni's agent, Danny Greenberg, referring to Baldoni as a deranged predator and warning Greenberg that Baldoni shouldn't attend the It Ends With Us premiere because no one wants him there. The second is alleged to have happened a week later. On July 22nd, 2024, Baldoni says that at the premiere for Deadpool and Wolverine, Reynolds told a senior WME executive that by representing Baldoni, WME was doing business with a sexual predator. And Baldoni alleges that Reynolds was doing this to pressure and later demand WME to drop Baldoni as a client. And I've got to say, as far as motions to dismiss are concerned, and particularly surviving a motion to dismiss, that's got to do it. It's pretty clear how calling someone a sexual predator is defamatory, and these alleged statements will go a long way to support a defamation claim as well as a civil extortion claim. And something I should mention is that on a motion to dismiss, the court is going to need to analyze the arguments, assuming the factual allegations of the complaint are true. That's not because the court is going to ultimately put some sort of a thumb on the scale at the end of this litigation. It's simply because it's too early to decide the case on the evidence when the parties haven't even had an opportunity to fully engage in discovery yet. Rather, the motion to dismiss is all about whether or not the complaint or the amended complaint has alleged enough that can hypothetically be supported by civil liability. This is one of the reasons why it's called a liberal pleading standard. It's intended to give all bona fide claims the full opportunity to be litigated in open court. And so here, Baldoni is ultimately going to need to put on evidence to prove that Reynolds made these statements and that Reynolds made these statements for the unlawful purposes that Baldoni claims. But that's a matter for a later part in this litigation. For now, he definitely has sufficiently pled these statements. Now, one more thing about these particular statements that I want to touch on before moving on is the fact that Reynolds also argues that the predator statements are statements of opinion. As I've said many times on this channel, a statement can only be defamation if it's a statement of fact, not a statement of opinion. Reynolds asserts this and says, hey, it was just my opinion that Baldoni is a sexual predator, and that's based on statements he's made about treating women poorly in the past, as he's talked about it in his book and in various podcast appearances. Specifically, he says in his motion to dismiss, while it is unclear what predator means to an average listener, it is quite clear that there is no discernible distinction between the gist of Mr. Reynolds' purported statements and the very behavior to which Mr. Baldoni has repeatedly confessed in public appearances, including that he spent years of his life mistreating women, which he attributes to a lengthy addiction to pornography, as well as openly describing his distorted conception of consent in sexual relationships. So now, a couple things here. Number one, to say that it's unclear to like a reasonable viewer or reasonable listener what the word predator means, that's a bit of a stretch. No one is confusing Baldoni with the monster brutally hunting Arnold Schwarzenegger and the other muscly men in Central America in the 1980s. We all know what the phrase sexual predator means. And quite honestly, Reynolds here is talking out of both sides of his mouth in this one sentence alone by saying essentially, nobody knows what that means. And then at the same time saying, but we can all guess why Reynolds said that because, he honestly believed it because Baldoni was talking openly about mistreating women in the past. I mean, look, show me a man who has never mistreated a woman in literally any way, and I will show you a man who has not interacted with women. Don't get me wrong, I'm not hating on men. Women also mistreat men in relationships. Every human does this thing on the road to becoming a better human and a better adult. Some do it more than others, but literally no one is perfect. And some people do struggle with various addictions, to include what Baldoni has very openly talked about. That doesn't make them horrible, evil people. And I have to say, I don't know that it's going to play all that well if Reynolds and the other lively parties are going to try to essentially crucify Baldoni for struggling with, and from what it sounds like, overcoming addiction. But also, for a motion to dismiss, the judge cannot consider extrinsic evidence except for in very limited circumstances. And this is not one of them. The judge is pretty limited to the facts as alleged within the four corners of the operative complaint, which here is the First Amendment complaint. And so ultimately, at the end of the day, that's not a good argument for a motion to dismiss. But getting back to this argument about the statements being just Reynolds' opinion, that also isn't going to fly here, according to Baldoni. That's because under California law, an opinion statement is actionable for defamation if the implication of the statement is that it's based on undisclosed facts. And this is particularly where the statement is factually specific, earnest, or serious in tone, or the speaker represents himself as unbiased, having specialized or first-hand experience, or having personally witnessed abhorrent behavior. And note that I said that this is under California law. Baldoni's side is arguing throughout their opposition that California law should apply to everything. Reynolds, on the other hand, argues that New York law should apply for a number of reasons. One of those reasons for why Reynolds wants it to be New York law is because New York has a more expansive view of what constitutes a protected opinion statement. And so that could potentially help Reynolds if the court applies New York law. However, Baldoni argues that even if the court applies New York law, the claim still shouldn't be dismissed on the basis of it being an opinion statement. That's because New York also doesn't protect what they call a mixed opinion, where the speaker implies that he knows certain facts unknown to his audience, which support his opinion and are detrimental to the person about whom he's speaking. And here, if you look at the alleged sexual predator statements, there's definitely an implication in there that Reynolds would know what he's talking about, as he's the husband of the woman who alleges sexual harassment in the workplace. Spouses talk about these kinds of things, so any reasonable person would expect that if Reynolds was saying that someone did something this horrible to his wife, that he knows what he's talking about. And so Baldoni essentially argues that regardless of whether the court applies California law or New York law, the defamation claim shouldn't be dismissed on the basis of these statements being opinion statements. And at any rate, whether the statement is fact or opinion is ultimately one for the jury to weigh anyway. So that means it's not an appropriate issue to be dismissed by the judge on a motion to dismiss. It's reserved for a jury. Anyway, then there's the group pleading issue. Reynolds argues in his motion to dismiss that the First Amendment complaint engages in impermissible group pleading by collectively referring to the lively parties, which includes Reynolds, when alleging defamatory conduct without specifying who among them made the statements. This is referring to the allegation that the group of defendants acted in this conspiracy to defame Baldoni and the others by confidentially leaking statements to the press about this alleged sexual harassment and predation. However, Baldoni's side also has a response to this particular argument. Specifically, Baldoni's side responds that they claimed that Reynolds, Lively, and the Sloan parties worked in concert to publicly and falsely smear them. They allege that they made statements to third parties, at the very least to the New York Times, that the other Wayfarer parties engaged in, permitted, and or failed to prevent sexual misconduct towards Lively. And while the Wayfarer parties don't have specific statements that they can quote verbatim, they do make two main points. The first is that under California law, less particularity is required in the allegations of the complaint where the adverse party has a knowledge of the facts superior to the party pleading them. And here they say, look, we don't necessarily know exactly what was said because it's all hidden by their secretive activity, but we intend to find out in discovery. And at this stage, we know that they said something defamatory because of all of these other circumstances we've been able to see around this behind the scenes behavior that they couldn't have really known otherwise except for one or all of these individuals talking to them. And ultimately, they say a statement underlying a defamation claim must specifically refer to or be of and concerning the plaintiff. And here they say there's no question that defamatory statements were made of and concerning the plaintiffs because the media ended up writing all of these articles regurgitating these allegedly defamatory statements. And at the end of the day, whether the statement at issue is of and concerning the plaintiff is an issue of fact, which is for the jury to decide. And once again, if it's for the jury to decide, it's not proper for the judge to dismiss the issue because that would be taking away something that is within the role of the jury. And honestly, I think these are good arguments. They're not as strong as the claims about the July 15th and July 22nd statements, but they are good enough to survive a motion to dismiss. And the assumption is, of course, that once the Wayfarer parties have had an opportunity to get discovery about these matters, they'll be able to shore up the strength of these claims as well. But for now, judges do not like taking away questions that are properly for the jury to decide. And if the issue comes down to that, the judge is not likely to dismiss the claim. Okay, so now to the part where we talk about why Reynolds filing this was maybe a huge mistake. Let me explain it by telling a little bit of a story of an experience that I had as a baby lawyer. When I was fresh out of law school, I remember talking with a retired judge who had moved back into private practice. And we were talking about strategy for a particular case, and more specifically, whether the defense should automatically file a motion to dismiss. And he told me that he almost never files a motion to dismiss when he represents the defendant. Now, as a baby lawyer, this was very surprising to me because in law school, I was definitely under the distinct impression that you should take every opportunity to get any lawsuit dismissed as early as possible if you're representing the defense. But he said something very important. For one thing, winning on a motion to dismiss is relatively rare given how low the bar is for the pleading standard for any complaint in litigation. So at the end of the day, most likely it's probably going to end up being more than anything a waste of time and attorney's fees. And even if you do get the whole complaint dismissed, usually the court is going to give multiple opportunities to go back and amend the complaint. And when the plaintiff gets to do that, you really just give them the opportunity to clarify and strengthen their case. And so instead, what he liked to do was just file an answer to lock the plaintiff's complaint in place with all of its defects. Then, after all the discovery has been exchanged between the parties on a motion for summary judgment, maybe you can pull up the evidence that you've gotten in discovery and get the case dismissed by showing the judge that the jury cannot side with the plaintiff on this evidence because the plaintiff's case has some material defects and the evidence just doesn't line up with it. I alluded to this a little bit in my video talking about Blake Lively's First Amendment complaint and why I thought it was a little bit of a mistake. If you watched it, you might remember how I said that there was one downside to Baldoni's side releasing all of the evidence that they did at such an early stage in the litigation. And that downside was that at that stage, Lively was able to pretty freely amend her complaint so that her allegations lined up a bit better with the evidence that we all know is out there now. And in that specific case, I was talking about the raw production footage from when they filmed that slow dancing montage scene. After Baldoni released that, Lively then amended her complaint because because when we all saw that footage, everyone realized it really didn't match up with what she had alleged. Now, there are other hurdles for her as a prime fact witness in both of these cases, of course, now that she's changed her story. But my main point in saying all of that was releasing the evidence to the public was a strategic decision by the Baldoni team, and Lively's ability to amend afterwards was a risk that I think Baldoni's side probably considered in making that decision. And that's very similar to what we're talking about with regard to the decision to file a motion to dismiss or just to file an answer in response to the complaint. Because either way, the defense has to file something. It's really just a matter of whether they want to fight to try to make the case go away early in a motion to dismiss, or if they want to just get moving ahead to the more substantive litigation by filing an answer and moving on. And remember how earlier in this video, I talked about how there's so much detail in this case that it's easy to get lost in the weeds. Well, at the very least in the court of public opinion, Reynolds has just given Baldoni the opportunity to clarify exactly what they say Reynolds did wrong here. There are obviously these statements that Reynolds allegedly said about Baldoni being a sexual predator. The alleged statements are already alleged in the First Amendment complaint, of course. They wouldn't be able to survive a motion to dismiss if they hadn't. But now Baldoni gets to highlight that Reynolds allegedly made those statements and that Baldoni is alleging that they are in fact defamatory. And Baldoni also gets an opportunity to dive into how he says Reynolds was specifically involved in the alleged extortion campaign and defamation that he says happened more behind the scenes when the group of defendants was supposedly interacting with the media. And so if anyone out there is overwhelmed by this super long timeline of events that Baldoni put out there, people can look to Baldoni's opposition to Reynolds' motion to dismiss for clarification on which claims and factual allegations apply specifically to Reynolds. And at the end of the day, even if the judge decides that Reynolds should win on his motion to dismiss on any of these arguments, most likely the judge is also going to allow Baldoni and the others to amend the complaint and try again. Defendants will often get multiple opportunities to get it right, assuming, of course, that the flaws in the pleading aren't completely fatal. And based on the arguments here, I don't see how anything in this particular situation would warrant otherwise. But those are my thoughts. What do you think? What do you think about the strength of some of these arguments that Reynolds and Baldoni are making here? Do you think that the defamation claim against Reynolds should be dismissed? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you would hit the like button. It does help us with YouTube algorithm gods. And if you're new here and you want to see more coverage of crazy cases and interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out there. And if you're really enjoying the content and you want to know how to best support the channel, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you in the next one.